Yes,
we
sir.
start.
Yes, sir.
I see.
Good afternoon, everyone. It's so delightful to see you all again here today. Thank you all for making the first 2 days of lecture a grand success. I welcome all of you to the third day of Constitutional Law Lecture Series conducted by the Department of Constitutional Law and Human Rights of the Tamil Nadu Dr. Ambedkar Law University. I'd like to thank the Honorable Vice Chancellor of our university, Professor Dr. N.S. Santosh Kumar sir, who made this entire event possible. I'd like to offer my hearty welcome to the man of the hour, the keynote speaker of the day, the Honorable and esteemed Professor Dr. Madabushi Sridhar Acharyulu sir, who is the Dean of School of Law, Bennet University. Welcome, sir. And I'm obliged to instruct the participants to kindly mute yourselves throughout the event. You're always welcome to post any relevant questions addressing the respected speaker and which will be answered by sir as far as possible in the question and answer session at the end. The topic for today is law of sedition and freedom of speech. The expert speaker is all set to give us an elaborate lecture on the topic, and hence let's initiate today's order of events. It's my greatest pleasure to invite Dr. Kumudaratna ma'am, the director in charge of PG courses. Ma'am has always been an inspiration to me and to many other students as well. I humbly invite you, ma'am, to render the welcome address. Over to you, ma'am.
Thank you, Harini and Ashwin, co-hosts. At the outset, a very wonderful, delightful afternoon to one and all present here, and also will be joining us in due course of time. I respectfully thank our Honorable Vice Chancellor, Professor N.S. Santosh Kumar, for affording this opportunity for not only the constitutional law students, but also to all of us faculty and the students of other institutions and other specializations also for learning more in depth about constitutional law. I would say we do not remember anything about constitutional law at all because we studied so long ago. And this is a wonderful opportunity afforded by our Honorable Vice Chancellor, sir. Thank you, sir. A very respectful welcome to you to this program. And moving on, I would like to welcome very respectfully and gratefully the chief guest and keynote speaker of this day, Professor Madabushi Sridhar Acharyulu. And sir, actually, thank you very much, sir, for giving us this opportunity, taking the time. I know you're very busy, and in spite of that, you have taken this time to enlighten us more about sedition, etc., aspects of the constitutional law. Thank you very much, sir. And to facilitate the public, the general public, the audience to know more about sir, I would like to tell some of the key lighting achievements and of the academic life of sir. Sir actually is the Dean of the School of Law, Bennet University, Noida, and sir is a gold medalist in LLB. And also he earned rather, I would say, 4 medals, gold medals in his course on Master of Communications and Journalism. And further on in LLM, sir specialized in law of crimes and torts. And sir's PhD topic is on media law. It is freedom of speech and expression in relation to law of defamation. And LLD also sir has done, and the thesis is on judicial legislation on privacy versus Parliamentary Act on right to information. And sir was sworn in as Central Information Commissioner in 2003. 5 years he served in this position, which is equivalent to Election Commissioner and Supreme Court Judge. And sir has given several landmark judgments when he was holding this post, especially in RTI, such as that patients, irrespective of whether it's a government hospital or private hospital, they have a right to their medical records, and also that educational qualifications is not personal information. And also that RBI has a duty to disclose the list of names of willful defaulters. And another important decision was a voter has right to be informed whenever his vote is deleted. There is so many more, but I'm just curtailing myself to this. And sir was a professor in Nalsar University from 2000 to 2013. And also sir was the chair professor of IPR during the year 2008-2009. And sir's professional distinctions, if you see, sir is a columnist in Sakshi. It's a very popular Telugu daily. Even I know about this, though I'm in Tamil Nadu. And also, sir was awarded Best Teacher in 2013 by the Andhra Pradesh government. Sir has authored 39 books. Of this, 24 are in English and the rest in Telugu medium. And Sir has written more than 100 research articles on law. This is truly amazing, and I cannot even conceive, writing 100 articles and all that. And Sir was also the status reporter on child rights in Andhra Pradesh in 2000-2001. And Sir was given, and also Sir has anchored a TV program in Andhra, that is Bhumi Kosham, and this was aired in the Telugu TV channel, and it crossed 61 weeks. And Sir's key publications are, I would like to tell about the title, RTI, Duty to Disclose. This was in 2019, very recently, and Right, Privacy as Secrecy. And this was in September 18, and Asian Law House is the publisher. And another very interesting, intriguing title is Bribery, a Family Affair, Analysis of Private and Public Servants. And another one is Constitutional Governance and Judicial Process. And another one about Nirbhaya Act, is it impossible to stop rape? And this is again a very interesting title to me. And Environmental Empowerment, Law of Expression, Law for Media. This again by Asia Law House. So like this, I cannot list out the entire, whatever book Sir has written, because it's going on and on. But thank you very much, Sir, for giving the opportunity for us to learn more about constitutional law. And moving on, I welcome very heartily the principals of the various government law colleges who are attending this program. We have totally 16 law colleges affiliated to this institution. Welcome to all. And a very sunny welcome to our Professor Dr. Balaji. He is the registrar of the Tamil Nadu Dr. Ambedkar Law University. Welcome to Professor Dr. Boneshwari. She is the director in charge of the UG courses. And a welcome again, a hearty welcome, a friendly welcome to Dr. Harita, who is the director of the Research, Publications and Academic Affairs. And also a welcome to the Controller of Examinations, Dr. Srinivasan R. And I welcome heartily Dr. Ashok Kumar, who is the director of the campus, both Pumbalil and Perangudi, and also he's heading the library wing of this institution. A very hearty welcome to one and all. And we have 9 departments. It is soon going to become 10 law departments, I'm told. And also we have 1 interdisciplinary department. I welcome, a very pleasant welcome to all the 9+1 departments in this institution, heads of the department. A very warm welcome. Thank you for taking the time. And as usual, my welcome to each and every one of the teaching faculty of this institution, of the affiliated law colleges, and also various other institutions who are joining in this program. A very hearty welcome, a courteous welcome to one and all. And I welcome very much with the hospitality, the teaching staff, and also the non-teaching staff and the technical team to this program, and especially a welcome to Mr. Darwin. Of course, he is only organizing, in the sense, arranging for this program, WebEx Meet and all that, but for him, we wouldn't be here. But still, my welcome to him. And always my special welcome, my enthusiastic welcome, joyful welcome is to the student community. They comprise of the undergraduate course students, postgraduate, and also the PhD. And again, like I said, they belong to the School of Excellence in Law, then PG course here in the School of Excellence in Law, and also from various affiliated law colleges and educational institutions throughout India. A hearty welcome to one and all. And I would like to especially thank Professor Dr. Reddivari Revati, the head of the Department of Constitution Law, for affording me this opportunity. It's a great pleasure and privilege also for me to welcome the gathering on this 3rd day of this of the series of constitutional lectures. Thank you very much, Dr. Revati. A very gracious welcome to each and every one of you present here, those who are in the process of logging in, and also those who will be joining in the due course of time. Thank you very much. Now, Ashwin and Harini, you can move on. Thank you.
Yes, ma'am. Thank you, ma'am. Thank you for welcoming all of us, and thank you for letting us know Sir's greatest achievements and immense contribution to the field of law. So now, without any further ado, let's begin with the main session. I hand over the stage to my co-host Ashwin to invite the respected speaker, please.
Thank you, Harini, and thank you, Dr. Kumda ma'am, for your warm words of welcome. You clearly mentioned everyone. And now we move on to the most awaited part of today's lecture. And I would love to invite, today we have a very special guest with us, as mentioned, as ma'am mentioned, a seasoned scholar in the field of law and journalism, Professor Dr. Sridhar. He has published and authored a plethora of books, as ma'am mentioned, including 4 on the Right to Information Act. Thus, it is apt that today we are going to discuss on law of sedition and freedom of speech, both of which have been a bone of contention since the post-independent era, and especially now more than ever, recently being the Supreme Court deciding on a case of Vinod Dua and quashing a case of sedition against him. So the problem, the issue of sedition and the contentions that the law of the freedom of expression has created over the past 70 years of our independence have still been questioned and are still being in the forefront. So I would love to invite Professor Dr. Sridhar to speak on this, and I would hand over the rostrum to him, before which I am obliged to request the participants to please turn off their mics and their cameras. And I know all of us are very excited for this lecture today, so please don't flood the chat box with too many messages, and please keep your questions relevant to the topic at discussion. Over to you, sir, without any further delay.
Thank you very much for all of your kind words. So, Dr. Professor Revati, Dr. Professor Kumuda, Professor and my dear friends, compeers, Harini and Ashwin, and the registrar of the Ambedkar Law University, Tamil Nadu, and other friends, teachers, faculty members, colleagues, and my dear students. It's a great pleasure to be associated with you in this afternoon to talk about a very hot topic, very serious topic, affecting everyone, every individual, those who use Facebook, WhatsApp, those who simply innocently forward a message, or those who speak something. Sometimes even if you read preamble in the public meeting, perhaps you are going to be charged for protesting, and protesting is converted into hate, affection spreading, and affection spreading is getting considered as sedition. So very, very vulnerable expression we are facing, vulnerable expression we are having. Our expression is vulnerable. Okay. Now coming to the topic of the day, we have already started with an introduction and a brief introduction about the topic I gave you, explaining the current situation. But before I start a detailed note, I'd like to tell you that I have left Bennet University and joined Mahindra University in Hyderabad as Dean and Professor. We are launching a law school very soon in Hyderabad. That's a small correction. You are not at fault. It happened in between. Before Dr. Revati spoke to me, and then I agreed. And yesterday I joined, and today I have a new laptop through which I am talking to you now. That caused some mistake, some communication regarding time. Okay. Well, first of all, I'd like to say that Indian Constitution is a democratic constitution. You all know that. Democracy can survive only with communication of opinion. Communication of opinion is the basis. Information is oxygen for democracy. Information has to be converted into a comment, a choice, a decision, an expression of opinion. Your vote at the end of campaign on polling day is nothing but your expression. I'd like to say your right to vote is a fundamental right, not because of 324, but because of 19(1)(a), because that's where you express your desire, your will to choose one of the contestants as your representative, who will ultimately rule the country for 5 years. So 19(1)(a) is the basis of establishing a democratic government. That you should remember. And when you are so important, when your views are so basic, when you are expected to be a vibrant, empowered, informed, and conscious citizen of this country, I suggest people should not remain as subjects. They have long back crossed the barrier of subjects into citizens. Are we citizens of India or not? We are citizens of India. So what is the difference between subjects and citizens? Subjects are subjected to all sorts of things, including suppression, taxation and suppression. They called us subjects with reference to taxation. But I am trying to tell you that If you don't want to be a citizen, you will be a subject. And with reference to suppression. So would you like to be suppressed with wrongful decisions by a democratically elected representative? Or would you like to raise your voice against wrong decisions of a democratically elected government by you? You have elected the government. And your government is behaving like this. And don't you want to expose, explain, express, oppose, protest, dissent? Are you not interested in doing it? If you are happy about it, if you aren't appreciate, I have no problem. They also do not have any problem. No appreciator of government has been charged with sedition nowadays. Nowhere in the history. So if you choose a safe path of appreciating the government and free from being sedition, you are welcome. I have no problem. But my question is, when you chose to act as an empowered citizen of this country, when you want to express yourself, I want to ask a question. In an election, if you want to defeat a ruling party, do you fear to defeat a ruling party? You know, will you be charged with sedition if you defeat a ruling party? No. In fact, you're throwing away the government, throwing out the government, and you're not being charged as for sedition because it's a legal means of changing the government. You have a wonderful power in your hand, that is ballot, and you change the government with your power. And before you change the government, you must know why you are changing it. Or you want to, what made you to change? And that is where you are becoming a very important person in participating in decision-making process. What is that process? You are intervening with the wrongful policies. You are questioning the wrongful laws. You are protesting something that's going wrong in executive government, and you are asking for a change of policy. And if you don't change, we will change you. You change. If not, we change you. So that is what the power of democracy in our country, in any constitutionally governed country. Now, when you are so powerful to change the government, why are you not so powerful to express your strong criticism against a particular policy is the question. Then criticizing government, in fact, I would like to say criticizing a prime minister is not criticizing a government. And criticizing government is not criticizing country. Criticizing country or nation is not criticizing nationalism. Criticizing the country, criticizing the government is not a disaffection. Criticizing the country is not provocation of violence. Criticizing the country can never be sedition. This is what we have to understand. The definitions are there, law is there, interpretations are there, Supreme Court judgments are there. We definitely refer to them, but basically you understand this point in a plain language. Unless we understand the issue in a plain language, we can't get into the legalese and understand the importance of our topic today. Now, one more point I'd like to say before I go into the details of sedition. You know, recently, before elections to Kerala Assembly, Kerala has proposed an amendment to Police Act to introduce section 113 E or B or something, 113. That gives power to police. See, the Police Act is meant for making police responsible, making police act according to law, punishing the people who went against law. But you see what kind of an amendment this is. They gave power to police to curb the expression of the people under Police Act. This is a very, very obnoxious way of dealing with or making a law. Then what happened? You know, people criticized, and that criticism is punishable under amended, proposed to be amended law. So then now what is to be done? Should we totally close our eyes and allow the law to be made? Or should we make noise? Should we question? this is the dilemma before the country, entire country, not only Kerala, entire country, because Kerala is part of our country, nation. So there was huge criticism. I also wrote a couple of articles saying that how it is replacement of Section 66A, which was abolished long ago. But you know, yesterday's news is they are being used. Thousands of cases are registered by the police in spite of the invalidation as unconstitutional by the Supreme Court. Section 66A is invoked. So what is happening? The entire country is watching at Kerala, which is reintroducing Section 66A through a camouflaged amendment, backdoor amendment to Police Act, took up freedom of speech and expression. Do you know what stopped it? Can you tell me what stopped the 113 being introduced in Kerala Police Act? Criticism stopped it. Public opinion stopped it. And how the criticism and public opinion emerged? Where from? From the exercise of Article 19(1)(a). Very interesting equation. Kerala government or some government wanted to dilute 19(1)(a), and by using 19(1)(a), you oppose the dilution. Kya baat hai? It's an excellent phenomena. And the point, somebody asked me, sir, is it possible for us to protect our constitution? I said, yes. How do you do? Use 19(1)(a), that's all. Use 19(1)(a), Brahmastra hai wo, Brahmastra. Use 19(1)(a), open your mouth, twist your, what is that? Forehead, twist your forehead, open your mouth, question. Don't be silent. Don't enjoy the century of Sachin Tendulkar and forget country, Indian nation. Enjoy it, I have no problem. But question this fellow also. A cricket, you know, even if you lose, doesn't matter, perhaps. Doesn't matter to the country. But if you get into a wrong law, it will affect you the other day. Okay, you enjoyed cricket today, tomorrow you go to purchase something and you will face the music. So this is the issue. Country wants your comment. Country wants your opinion. Nation wants your opinion here. Why are you not giving? So if you are silent, if you don't talk, if you don't use 19(1)(a), if you forget 19(1)(a), not only 19(1)(a) will die, but the entire constitution will go. So in my view, if you ask me which is the most important article in this Indian constitution, I'll not say president, I'll not say Article 21. Article 21 will be there if you are alive, yeah. I'm telling you, you are in jail, you will be killed, kicked. So before you are killed and jailed, talk about it. So Article 19(1)(a) is the only way to protect 19(1)(a) and the constitution. Sedition or no sedition. UAPA or no UAPA. Draconian government or no government. Terrorist law or no terrorist. Whatever it is, whoever he is, don't fear. If you fear, I can't say anything about it. There's nothing that I can say. And governments are interested in generating fear, inculcating, infusing fear. Because if you're fearsome, if you're fearing, if you're uneducated, if you're unquestioning, if you're confined to your one-day cricket, they're very happy. They're very happy. You're also perhaps very happy. But what about the country? What about the good governance? What about constitutional governance? What about parliamentary democracy? What about everything? Your life, my life. So this is what one has to think. So somebody asked me on RTA also, sir, how do you protect RTA? I said, by using it. Use RTA. That's all. Abusing, of course, I don't agree with abuse. But I don't agree mostly against, my greater disagreement is against non-use. Non-use of 19(1)(a), non-use of constitution, non-use of RTA, non-use of opening, non-use of your mouth. If you don't use your mouth, you will get Hindi mouth. So this is my basic point that I want to tell all the people, all the citizens in this country. And this is the real education I think we should know. Then coming to the government, coming to the restriction. Yeah, I agree. No right is unrestricted except one. Can anybody tell me what is that one? One right is absolute. Can anybody say that one right is absolute in India? That too under Constitution. Anybody, please? I have hundreds of students here. Anybody can open mouth? There's no absolute right. Somebody says there's no absolute right. Article 21 is not an absolute right. If Article 19(1) is an absolute right, Father Stan would not now died in jail, hospital. Yeah. There is no absolute right. That's what your conclusion is. A certain limitation in 21. Yeah, Article 13. Yeah, kya bhai, Article 13 right hai kya? I'll tell you. You will not find in the numbers, No right is absolute. Mani Madhavi, come. Prabhakar sir, about human right. Everything is human right. Yeah, kya bol rahe aap? Sri, I'm in a webinar. Yeah. So, my dear friend, read preamble. All rights are not in their part 3. There are some more rights beyond part 3. Natural rights. Right, liberty of thought. Liberty of thought is, even if it is not mentioned in any of the articles, and I wish it is not mentioned in any of the articles under part 3. Do you know why? If you mention it, they'll limit it. So I don't want anybody to limit my liberty of thought. A liberty of thought is unlimited, and it is not possible for anybody to limit it. Only you can limit it by not using your brain. I can't help. I can't help. So liberty of thought is absolute. But an absolute liberty of thought is essential to exercise to express an opinion. And liberty of thought also is supposed to be preceded by another important right, that is right to information. My point is, unless you have something before you, some knowledge arising out of information, how do you exercise your thinking right, and how do you exercise your expression? Education is a very, very important basic line of functional democracy. Get educated. Reading newspaper is not getting information. It is getting educated. I say it is getting educated. So get educated and then become informed person, informed citizen, and then express your view after thinking, after exercising liberty of thought. So this is the point I thought I should emphasize, because I have all the thinkers before me, professors of law. They know the administration. They know how a government functions, or they know at least how a government should function. So I wish them that they also agree with what I am stating now. Fine. Then coming to the restrictions. There are restrictions on restrictions, if you know that, if you agree. What are the restrictions? First, restrictions are restricted to grounds listed in 19(2). Remember, very, very important. Don't invent a new ground which is beyond 19(2). Very, very important. Then second important restriction on restrictions is it should be by parliament, not by executive, not by rules, not by regulations, not by judgments also. No judgments, no rules, no regulations can restrict freedom of speech and expression beyond what is supposed to be restricted under 19(2). Very, very important point. In some of the judgments, Supreme Court said, invented a new one, doctrine of postponement of publication. It's a beautiful word. Doctrine of postponement of publication. That means what? You don't write anything about the rape committed by Mr. X, a very, very important man. Don't write. Postpone. Till when? We'll tell you till when. What does it mean? It means cancellation of your right of freedom of speech and expression. And I would like to ask the honorable judges, where from you have got this power to restrict like this? Where from? Kahan se mila aapko? Macaulay diya kya aapko? Whether Macaulay has given it this power to you? Huh? Who gave? Ambedkar diya kya? Unfortunate, it exists. It exists even today. Okay, because courts have done it, nobody questions. Those great lawyers who can stand before the topmost honorable judges and get the order of postponement of publication, they'll be free from media's attack, and others are finished. Okay, leave it. I'm just giving an example that how a judgment cannot impose a new restriction. Come to IT rules, new IT rules. Do you know what are those rules? 2021. Earlier it was 2011 intermediary liability rules. But now it is not intermediary liability. It is media liability rules. So they entered through a small hole of a needle into the big area of media. And they are trying to control what? Control print media and digital version, electronic media and digital version, and digital media anyway. So what is left out? Can you explain intermediary thing, sir? Intermediary means like this Google and other service providers. So can you make a service provider liable or not? It's a question. It's a question. So I established a university. Yeah, established a university. Hostel. I'm giving you food. Of course, you are paying for it. I'm not freely giving. Now, what can you do in the hostel? There are certain activities that you can do. Suppose you commit a criminal act, what will happen? Do you make the university the owner of land liable, owner of building liable, or the owner of what is it? Whom do you make liable? It is not question of immunity given to the owner of the land. It is question of imposing liability on a person who committed crime. We have to understand that. Now, Google provides everything. I'm not defending Google. I'm only talking about it. I'm only using it as an example. Similarly, YouTube or something, whatever it is. So 2011 intermediary rules talks about the liability only in certain cases, liability in such circumstances when you did not remove the offending material or defamatory material or obscene material or porn material, even after complying, you are liable. Fine. Because you hold the power of removing a piece of content from the platform, you are made liable. Fine. So you are making rules for Information Technology Act 2000 and trying to impose new restrictions on media. This is not what is envisaged by 19.2. Second point. Third point is the restriction that you are imposing must be reasonable. That means ground is okay. Ground is listed, law is made, Parliament made it. Now question is whether that restriction is reasonable or not. Every offending material can be removed is the law, let us say. So when I'm saying rules, okay, government of India will go back and make a law. Let us suppose, first condition is fulfilled, a ground is created, and they made law. Now question is, offending material, any offending material can be removed. Can anybody under the sky define what is offending material? That means a vague expression. Recently, the United Nations rapporteur on freedom of speech and expression gave a report saying that ambiguity of expression, ambiguity of restriction is draconian. in practice. Ambiguity of expression is draconian in practice. And that makes expression to suffer, to be suppressed. And the commissioner of police or sub-inspector of police, if he is not happy with you, he can simply say what you said is offending, and you are finished. That is what Section 66A was. Section 66A has gone because it is ambiguous, too open, too general, and anybody can interpret in any way. And what is offending to me is not offending to you. And I'm a ruling party man, and both of us say that what you have done is offending, and I'm bad. You know, in sedition, I'll give you, with regard to one small procedural thing. Sedition has to be sanctioned by the government. Sedition case, unless sanctioned by the government, it cannot be. But see what is happening today. Somebody writes a complaint to a police station, he will register it. 100 plus senior citizens of this country wrote a letter representation to Government of India saying that the damage caused to Article 370 is not correct. Correct or not is limit. Let us not go into that. So when you say that, when you write that 370 changes are not correct, you please go back and review. A police station registers a sedition case against all those 160 fellows for writing that letter. You can't do it. You can't do it. Police do not know that. Police do not. Only the person who studied under your law university, constitutional law 2. And if it is in syllabus, and if the lecturer covered that syllabus, then you know. And that lecturer goes to this minute aspect of procedure. Need not go, na? And say, no, unless there is a sanction, you cannot. That is the problem in this country. Okay, so these are the points. Restrictions also I covered. Now let us go to sedition as a restriction. Sedition, what do you call in Hindi? Rajdroh, Rajdroh or Deshdroh, or which? What do you call? Rajdroh to some extent is correct. Deshdroh is not. I'm criticizing the government. I'm not criticizing my country. My country is a great Mahabharat. Mera Bharat Mahan hai. Salute. But मेरा प्रधान, मैं इनके बारे में बात कर रहा हूं, बस इतना ही. इनकी पॉलिसी के बारे में, not against him, but about the policies. Then should I or should I not? Even a bitter criticism, a very strong, negative, bitter, hurting, offending criticism is not sedition. What is criticism? Negative criticism is not correct. What do you mean by that? Criticism is always negative. There is no positive criticism. If you understand praising is also positive criticism, I'm happy, do it, and no problem. But when I say that your government is not functioning according to Constitution, it's a negative criticism. Constructive, destructive, I don't go into that. If I think, I know you say that. Constructive, what do you mean by constructive criticism? What do you construct? What is destructive? I say this government has to go because it is not following the Constitution. Am I destructing it? I am preparing my voter to vote against him in the next election. And it's my legitimate right, duty under Constitution. If I am exercising my right, duty, and it is something like evasion and avoidance. Tax evasion is a crime. Tax avoidance is not a crime. So I cleverly avoid. I'm a very senior lawyer. I'm sitting in Supreme Court chambers. I avoid. Income tax fellow says you evaded. Now the litigation. So this is my finer distinction between constructive, so-called. It's only jugglery of words. So I criticize it, you didn't like it, and you call me destructive criticism. And then if you are so violent, you make a police station nearby under your influence to register a case of sedition against me. And nobody knows what is the meaning of definition, what is the meaning or definition of sedition, neither you nor the police station. This is the problem. क्या करना? Now, why this law has come to this country? I would like to tell you, before independence in our country, will anybody accept if I say there was freedom of speech and expression before independence? Will anybody accept? But the reality is, it was there. I'm not talking about post-independence. I'll talk about it. Now I'm not talking. Mr. Pranit, I will talk about those points, don't provoke me now. I can talk or answer your questions also. But listen to me first, what I am trying to say. You have question hour. My friend Ashwin will take your questions and he will edit it. Perhaps, I hope he will edit it. Reasonable restrictions on your freedom of speech. And then I'll answer it. Okay. So what I am trying to tell you is the freedom of speech, which was not statutorily recognized before independence, was available in practice. If it was not, Gandhi would not have written articles, Nehru would not have written articles, would not have traveled all the country, all over the country. No, his travel itself was inspiring. Travel, yeah, nothing, no meeting. So, har ek station mein rukta tha, Gandhi ji. He used to come out of that third class compartment. That was inspiration. कुछ बोलने की जरूरत भी नहीं थी. There was no need for saying anything. That was great personality, leader. Okay. Now, what were the restrictions? Freedom of speech was not defined. Then what were the restrictions? That is the dangerous part that we should know. Defamation, criminal defamation was a serious restriction. Do you know what was criminal defamation? I don't know whether you have studied it. Article, section 499, 500. Very, very powerful codification of law of defamation. Criminal defamation in our country, 499. According to, I'll ask you one question. Suppose somebody says 500 is for punishment, 499 is the definition. So if somebody says, so-and-so, Murdabad, so-and-so, Murdabad. Murdabad ka matlab kya hai bhai? Murda means death. He says, X Murdabad. I don't want to give an example also, living leader's name. I don't want. Because there is no necessity, you will understand. Suppose I say Mr. X Murdabad. Am I committing criminal defamation? Can anybody tell me? Suppose I burn an effigy of chief minister. Which chief? Don't ask me which chief minister. Just understand, chief minister. Don't be so interested in people. Be interested in issues, not individuals. So if I burn effigy, I'm virtually performing lost rights of a person who is living. I'm not supposed to do. Am I at least causing criminal defamation? I was. And you know, the initial prosecutions under Indian Penal Code, 1860, it was criminal defamation. People were prosecuted, jailed for saying Murdabad. British Queen Murdabad, British Secretary General Murdabad, somewhat, whatever it is. Some Rao Bahadur Murdabad is jailed. I agree. To that extent, there was no freedom of speech and expression. Then sedition. So now let us discuss sedition, wonderful restriction, topic of the day. And not that I am not discussing it all this time. I was discussing, but I'll give you some more details. So when Indian Penal Code was introduced in 1860, the Law Commission chairman at that time was, you know, that wonderful personality, Macaulay. Yeah. Macaulay is a wonderful personality, all said and done. We may not agree with him. This Indian Penal Code is working today, 50 countries have copied. 50 countries have copied, including England, copied Indian Penal Code. So we made a wonderful draft. Some of the drafts we don't agree with. And one such draft is Law of Sedition, 124A. At the time, it was 113. But somehow he could not introduce it in 1860. Either he forgot or somebody, typist has done some mistakes, we don't know. Typists, sometimes they do great contribution to the nation by forgetting to include draconian laws. So it was such a contribution in 1860. Then what happened? Or there is one more criticism, let me say that. The law of sedition proposed by Macaulay was not in consonance with English law. Not in consonance with English law. English law was reasonable. English law of seditious libel was reasonable. Indian law of sedition was draconian. English law, I tell you, it's a misdemeanor punishable with 2 years of imprisonment. In our country, it is life imprisonment can be given, or at the time it was deportation from the country, or sending them to a cellular jail of what is it? Andaman or whatever it is. Whatever they like, not you like. That was the situation. Then second point, most important point was to convict somebody under sedition, the jury must give unanimous opinion. You know, there used to be juries at the time. We don't depend on opinion of one single person, judge. And we are doing it today. One single person, we don't know what are his moods. We don't know what is his background. We don't know whether he will fear or doesn't fear. Whether he has any lenience or not. We don't know anything about the judge who decides our fate. And depending on his moods, our jail is decided. Our bail or jail, whatever it is. So BJ, very little difference. If judge suddenly says jail, we are finished. If he considers that we are lucky, we'll get bail. So that is the situation today. But that was not the case during British regime. Jury has to apply their mind, and all jury must unanimously say that, yes, it is seditious libel. Then only you will go to jail. And that was the law in where? In England, not in India. And India, do you know what they did? Majority jury opinion is enough. Why should it be? Why do you have a difference between Indian citizen and British citizen? Are we not human beings? So that was the situation. And then the jury consists of majority of white men and minority of Indians. I don't say black men, minority Indians. So even if Indians suppose that it is not saying that it is not sedition, they would have not avoided the conviction. So when Macaulay made a law which is not in consonance with the British law, even the other members of British Law Commission, they refused to allow this. But in 1870, after 10 years, 124A means what? It's an additional section inserted in 1870. And that is what you are still continuing. What a shame. What a shame. 1870 law is made, and you are in 2021. You are still continuing. How do I describe the government? Which language I have to use? I don't know. A police officer came to me and said, "Sir," I said in a lecture, by law you are suspected. By law you are suspected. What, sir? What is this? Yeah, confession made to police officer is not admitted. Why? Because we suspect him. I'm not suspecting X or Y. I'm suspecting entire police force of the country. Not by my letter or speech, opposition leader's speech, by law. Section 25, 26, 27 Indian Evidence Act. I suspect him. Then he realized, sir, so since when it is 1872? We are suspected. Why we are still suspected, sir? Why do you ask me? You ask Chief Minister. You ask Prime Minister. You ask Indian Law Commission. Why do you ask me? Then do you know what this fellow did? This fellow went for training to England. Britishers he met, and he asked, why did you make such a law for India? Why do you suspect all police force? Then do you know what he said? Okay, sir, we are fools, sir, whatever it is. We did it. 1947 से आप क्या कर रहे हैं? What is it you are doing since 1947? इनको अब tubelite has brightened, and then he came back to India. Why we have not done? This is what I am asking. This is what you have to ask. So that is the law. And even today, you did not change. I think you know that. Even today, we can't change. I'm happy that we are not changing it. Had we changed it, all of us would have been finished in police stations. Luckily, it is not changed. I am happy. Now, we are not changed other law also. One is Official Secrecy Act. Second is sedition. What is official secrecy? We are not talking about it, of course, but I'll just make a mention. Official secrecy is a oxymoron. If it is official, it should be in public. If it is personal, we make it secret. I don't want to know your wife, your husband, your children, education, your choice of sex, your choice of religion, your choice of house, choice of food. I'm not bothered. Your secret, chalo, lagao, secret. Don't write it on Facebook, but we do that. We write, I ate this today. Why should I know, yaar, what you have eaten? I'm going to this movie, watching this movie. In what way I'm interested? I'm traveling. They give location also, traveling. Delhi to Bangalore. I don't know why they give. Okay, leave it. So your privacy is your secret. Your official matters are not secret, should not be secret because it is official. Unless some security plan, some national security, fine, agree. So this is about, we have not removed Official Secrets Act 1923. And we have not touched one of the greatest draconian laws of the country. Completed 150 years, 1870. Kitna hua bhai? Celebrate 150 years of sedition law. 1870, 2020 se shuru hota hai. 150 years celebrations. And how do we celebrate? We celebrate by left, right, and center book cases of sedition. Chalo, celebrate. Book case of sedition, celebrate sedition. And we have celebrated. And we are waiting for celebrated judgments. Now and then they come. I'm happy that they are doing it. At least that Akhil Gogoi. Do you know what the judgment, very interesting judgment. I want you to read July 1st judgment of Guwahati NIA court. He wrote wonderful judgment. It is a 120-page judgment, latest on sedition. He says, do you know what he says? Kedarnath, this is the decision. 2016, Deepak Mishra, this is the decision. And then he says, unless there is an element of provocation to violence and possibility of violence or existence of violence, provocation with an intention to create violence, evidence of somebody being provoked to commit violence, and evidence of commission of violence. Three are important components. You know, in our constitution, how long I have to continue like this? Any restriction on my time?
No, sir. We
4
have
minutes?
time till 4:30. We can continue till
15 minutes?
20 minutes.
Yeah, fine. So Kedarnath case, 1962. Somebody wants me to repeat the name. Kedarnath case, 1962. And Akhil Gogoi's case, 2021, July 1st. Very recent, yeah, 5 days ago. And then Vinod Dua case, my dear friend has rightly mentioned. I'm very happy that he mentioned it. Good, you're abreast with the current affairs. Shocking current affairs. Okay. Now, there is another very important case, Dhananjay Chandrachud case. I wish you read it. In Raghurama Raju's case, MP Raghurama Raju. You know, you and I don't have freedom of speech, I agree, to some extent. But how an MP doesn't have freedom of speech and expression? Member of Parliament. And all we read under parliamentary democracy class, Constitution Law 1. What do we study? Absolute freedom of speech and expression for MPs. On the floor of House, of course, on the floor of House. But that fellow, being a ruling party MP, unfortunately, is subjected to false cases. And then third degree, yeah, what nonsense is going on in this country? Third degree to an MP, beating and live telecasting. Do you know, he wrote a letter to the Speaker of Lok Sabha saying that the Chief Minister wanted to have a live telecast of his beating in police custody. And they have catered to the need of the leader. Catering service. Catering service was done. Okay. Now, do you know what Supreme Court said? Very interesting. One must read that order. Dhananjay was at his best in that judgment. Do you know what he says? The charge sheet cannot stand. Charge sheet not even a charge sheet. FIR cannot stand on 2 points. One, the language of complaint in FIR doesn't disclose the possibility of prima facie sedition case. Possibility of prima facie sedition. Second, he was subjected to improper treatment. Judge restrained himself to use the language. Restrained. And what is the language used? Improper. What is it? Improper conduct of the police. What is improper conduct of the police? Anybody can understand. He will not offer a cup of tea to you instead of coffee. That is not improper. You know what is improper. On these 2 counts, he was given bail. Luckily, the Supreme Court is real guardian of constitutional rights. If not, we do not know what will happen to us. But how many of us, for forwarding a message in WhatsApp, go to Supreme Court and ask Dhananjay Chandrachud, please give me bail. Will he hear me? Can I go there? Can he? That's a big question, of course. So what I'm trying to tell you, if you read Vinod Dua, Raghuram Raju, Akhil Gogoi case, what you understand is there are clear definitions of contours of criminality of sedition. By whom? Not by Macaulay, but by our great judges, 1962. Great judges, 2016, 2021, great judges. And you know, you have a wonderful provision in our constitution that law declared by Supreme Court is law applicable to entire country. You know? But 66A is not applicable. We will book thousands of cases. So we defy article. We defy Supreme Court judgment. We defy that. We defy. Somebody suggested me recently, sir, you talk about all these things, you write all these things. Why don't you create a force for each court to implement its orders? So High Court of Tamil Nadu, one force, border security force. One force to Supreme Court, you know, Indo-Tibetan border court, police. So we distribute. Then I said, there will be a fighting between these 2 forces. Supreme Court force will be fighting with Tamil Nadu force. So the total entire country will be, you will find civil wars. So we can't have our own force. We can only give orders and you have to execute it. It is your duty. And what can anybody do if you still book cases, thousands of cases in every state under 66A, which is struck down? Shreya Ghoshal, we admire that student, law student. Perhaps we have felicitated, and we have appointed him, given. But 66A did not go. What a... If a specific order of Supreme Court regarding 66A is not implemented, you tell me, can you implement the definitional contours, limitations on interpretation of law of sedition will be implemented in this country? I'll ask you a simple question, because you are law students. Where sedition case is booked? In a police station. Who will book a case? Not LLM, PhD, LLD like me. Somebody who passed BA or BCom, we don't know whether he passed really or not. And he will not disclose his BA under RTA. We can't see you. You can't see me, but my video is open, my voice is open. Can't you see me now?
Yes, sir. Yeah, we can see you, sir.
Okay. Listen to me here. What is there in seeing me? क्यों देखना चाहते हैं आप? मैं जो बोल रहा हूँ सुनो. So now a police station, a clerk, a writer in police station, a sub-inspector, circle inspector in police station will book the case based on what? Indian Penal Code. Indian Penal Code का एक book रहता है उनके टेबल में. He will open 124A. चलो book करो. He will not read Deepak Mishra's judgment. He will not read 1962 Kedarnath, When you also do not know Kedarnath, how do you expect him to know Kedarnath? So Kedarnath, he doesn't know. Who is Kedarnath? He doesn't know. You know what happened in 1994 or 1995? There was a case against two, I forgot the name. There was a case against two education officers of Punjab. Two education officers, education department. They raised slogan in favor of Khalistan. Khalistan Jindabad. Chalo. Khalistan Jindabad. He did not say Indira Gandhi Murdabad. He said Khalistan Jindabad. Good or not? Balwant Singh case. Thank you, Yogesh Gupta. Balwant Singh case. In Balwant Singh case, that fellow says Khalistan Jindabad in connection with Indira Gandhi's murder. They are educated people. One is Deputy Director Education. The other is a clerk. Both of them together, they raise a slogan. Why did they raise? I don't know. Then they were charged with sedition. Then lower court, High Court convicted him. They came to Supreme Court. Supreme Court says a bit of emotion, maybe under impression, under influence of some ideology, some speech, some emotion, some anger, unjustifiable anger, unjustifiable emotion, unacceptable slogan. Unacceptable, I agree. I don't appreciate that. Unacceptable, unjustified, unreasonable, not at all warranted. But is it sedition? Is it sedition? No. There are different grades here. Somebody is trying to throw a stone at you. And you have somebody thought like me, you thought, oh, your right of self-defense, section 100 Indian Penal Code. Chalo, 100 yaad aa gaya. 100. I pick up my machine gun, AK-47. I have, my grandfather purchased it. AK-47. Will you shoot him out? Because he raised a stone against you? Will you shoot him out? Do you have a section 100 protection? You don't have. So even if it is unacceptable, unreasonable slogan, it is not sedition. Tell me which sub-inspector of police will read the judgment in Balwant Singh? Then what will happen to your 141? Law declared by Supreme Court is law of the entire country. First, you have to understand this point. How to implement Supreme Court's wonderful orders. How to implement them. And if 66A cannot be implemented, 66A order cannot be implemented, what will you do with Supreme Court? Why should we go to Supreme Court? What is your Article 32? Why do we talk about all this nonsense? Why should I teach law in classroom when it is not being implemented in spite of being approved by the Supreme Court? This is the problem. Now, okay, I'll talk another aspect of sedition. Sedition, I think I have explained you why sedition is bad law, why it is abolished in English. When it was being introduced in India, England stopped using it. When it was introduced in India as a draconian law, a minor offense like law in England was not being used. Every other knowledgeable country where empowered citizens are there, it was abolished. It was not abolished only in India, where we are claiming that we are empowered citizens of India. I doubt whether we are. Sedition. What kind of a sedition it is? I just cannot understand. So if at all you are conscious about law and you are a scholar, student of law, constitutional law, if you want rule of law, we must oppose sedition to save this country, to save this democracy, to save our Indian constitution, and to save India. I love India. I may not sing a wonderful song, but I love India. By opposing sedition, I am loving India. I need not write a love letter to President of India to say that I love India. But I can write a letter opposing sedition to President of India to love India. So I wish all of you love India like me. And I would like to stop here and ask questions if you have any.
Yes, sir. Thank you so much, sir, for that. That was a really amusing and engaging lecture that we had. I'm sure all of us really enjoyed listening to you. And we've had an overwhelming amount of messages in the chat box and a lot of questions. So I'd probably ask Harini to moderate the questions to you.
Yes, Ashwin. So thank you, sir. It was really engaging, sir. There are few questions. One is, would hate speech come under the ambit of freedom of speech? Since neo-Nazis are allowed on Facebook, where to draw the line, sir?
That's what is the question now.
Yes.
Even if you hate somebody, it is not sedition. I'm not approving hate, but I'm trying to tell you it is not sedition. Don't hate. But if somebody hates, try to convince him, but don't impose sedition case against him. That is the answer. So how to understand? How to understand? How to differentiate between hate and criticism? So go by the definition and meaning of sedition. First, understand dictionary meaning. Apply it to the situation context. देश को टुकड़े टुकड़े कर देंगे. Yeah, wonderful question. So आप कर सकते क्या बातों से देश को टुकड़े टुकड़े कर सकते क्या? अगर कोई टुकड़े टुकड़े करना चाहे तो जरूर लगाइए उनके अगेंस्ट केस. There are so many cases, so many laws. Do it. Even sedition, I don't mind. Come on, have a sedition case. Who is doing country tukde tukde? Who is doing? Which tukde? Which tukde you are supporting? Which tukde I should oppose? So it's all subjective. This sloganism, emotional, political speeches. I don't get trapped into these political emotions. Understand with reason. Use your brain. If you don't use 19(1)(a), according to Darwin, it will deteriorate and it will disappear. According to Darwin. And if you don't use your brain, I don't know what to say. Please use brain and use 19(1)(a). Use discretion. Yeah.
So another question is, if freedom of speech is a fundamental right, why can't we question judiciary on any of its judgment?
You please question. Who stopped you? You must have guts to question. Guts means study, research. Question. Do you know Upendra Bakshi? He wrote a letter to Chief Justice of India opposing the judgment of Supreme Court in Mathura case. He opposed it. And because of his opposition, law of rape is changed. So you still have wonderful 19(1)(a). And if you go to Contempt of Court Act, there is one section which says that criticism of a judgment is not contempt of court. There is a specific statement. And you go to section 499, one of the exceptions says criticism of court is not contempt. Judgment. Criticism of judgment is not contempt. What more you want? The problem is we don't read. Problem is we don't understand. Problem is we don't think and we don't express. Use 19(1)(a). Again, my slogan is use 19(1)(a).
Another question is, can sedition be a part of restrictions in 19 Clause 2?
It is now. That is the whole problem.
I don't think there are other questions, Ashwin.
Yeah, I think I've gotten a few in my mobile. So some of them are asking with regard to the recent cinematograph amendment, sir.
Which one? Which amendment?
Cinematography Amendment Act, where the government has the power to request the authority, the certification authority, to recheck the film if there's anything that goes against Article 19 Clause 2, sir.
Yes, it will go. The point is, all the tribunals are being abolished. All the tribunals, including the censor appellate tribunal, and whatever the committee decides, you have to abide by it or go to High Court and file a writ petition. So you are seriously undermining the right of appeal of an expresser, a person who expressed through cinematography medium. to retain the expression and argue that it is reasonable. So that opportunity is, recently Kamal Hassan has written a very good article on this. I suggest people to read it. It is about just one tribunal. There are other tribunals also which have gone, including that income tax appellate tribunal, not income tax, Indian intellectual property rights. That appellate tribunal is also gone. One of my students got selected as judge of IPR, appellate tribunal. And because of this, he came back to Hyderabad to be my student again. So this is not
Right.
correct.
Yes, sir. And also another question with regard to the entire existence of Article 19, Clause 2. They say that it was in itself. I'm not sure if you would have heard this book by Dr. Tripurdaman Singh, who's written on the First Amendment of the Constitution.
Yeah.
Yes, sir. So there's a question about that, sir. So is it it is basically bringing things that are worse before independence? As you mentioned in your lecture, sir, before the independence, we had only certain things that would accuse you, or that could that person could charge you for sedition. But after independence, it actually became worse, and that too, it was a politically motivated stunt. So what is your opinion on that, sir?
Yeah, my First Amendment was the tragedy to the just born Constitution. The same Constituent Assembly which has passed the Indian Constitution has passed as a parliament. It was a parliament acting as a parliament before 1952 general elections. Even before the country elected a new parliament, they amended the Constitution. That is absolutely wrong. And I'm unhappy with that amendment. And what is it they have done? If the American First Amendment protects the freedom of speech and expression, Indian First Amendment destroys it. And you know what it says? Public order. What do you mean by public order? Can a sub-inspector of Tamil Nadu police station understand what is public order? And will he call the professor of Tamil Nadu Ambedkar Law University to explain what is public order? He will simply register a case and throw you into jail. Now it is your duty to use 226, 32 nonsense, all that. And always you should get Dhananjay Chandrachud. Will you get? So these are all the problems, So you are not implementing the Constitution. You are not allowing judicial precedents to be working on the field. You do not train your police officers with the judgments and interpretations and guidelines given by the Supreme Court. So you are worse than, I can say you are worse than the earlier situation. And this ambiguous grounds like public order, they destroyed the freedom of speech and expression. Nehru and why only Nehru? The entire members of Constituent Assembly who are acting as the members of Parliament till 1952 are responsible for this destruction. I'm very unhappy with this First Amendment. Not only on this, on land, the property rights and other also. First Amendment as a whole is a worst amendment.
Right.
That 16 months of turbulent, there is one more book. Read that also.
That was that.
Read that also. Terrible, terrible. They killed Constitution in the first year itself. Those who made. Some animals are there, the cannibals. They eat their own children.
Yes, sir.
Unhappy
and I
situation.
think, yes, sir. I can conclude the question and session with the last question which I've received. It is with regard to, you mentioned that only if the wonderful orders of the Supreme Court are implemented, can we have a proper rendering of justice. So what would be, in your opinion, practical steps to implement these orders, sir?
People should remind the people in power. People in power are in sleep. We have to wake them up. People in power include sub-inspector. Your sub-inspector should be told that this is not sedition. They should be told. So a local citizen, a powerful citizen of that area, an informed citizen of that area should question. See, you need not be a celebrity to question the wrong that is going on. So booking of a case itself is not correct. So somebody should raise a question. And I wish a magistrate should have guts and he will behave like a vertebra. to question, no, this is not sedition, like that Gauhati judge. Thanks to Gauhati judge. And when the medical bail petition was postponed, the court should have granted stay on death of father Stan. They should have granted a stay on death. He should not die, bolke dena tha. When you can't give such an order, which is unnatural, how can you postpone a medical bail petition? That is my question. Where is humanity? Where is natural law? Where is humanity? So people should question, keep questioning. 19(1)(a) should be used.
Right, sir. Okay, sir. So again, I would like to remark, it's been a really engaging session and very amusing. I am sure all of us have really enjoyed listening to you, and we've learned a lot of things. And
but I want them to think about it. Enjoyment is fine.
Yes,
right.
sir. Yes, sir.
I'm happy that I hope they will, out of enjoyment, they'll think, I hope.
Definitely, sir. You've lit a candle in their minds. So definitely that will cause a sort of a thing. Yes, sir. And I think we can move on. We can conclude the session. So I'd request Dr. Rajalakshmi to render the vote of thanks.
Am I audible, Ashwin?
Yes, madam, you're audible.
Thank you, Ashwin. Appreciation can change a day, even change a life. Your willingness to put into words is all that is necessary. I am gratified for giving me a chance to deliver vote of thanks to such a wonderful expert speaker and audience. The Tamil Nadu Dr. Ambedkar Law University is honored in organizing lecture series on constitutional law today. First, I am thankful to Almighty for giving us courage and spirit to arrange this glorified event. His blessing has turned this event of today into a grand success. My heart fills with lots of gratitude and respect for Professor Madabushi Sridhar, Acharyulu, Dean, Mahindra University. Thanks a lot, sir, for this comprehensive and wonderful session. One of the finest example of right to freedom of speech and expression was also this session itself. Constitutional and criminal speech as incitement to violence is most vibrant topic personally for me as a teacher of criminal law. Today I got a new insight on this topic. Such a well-balanced analysis. Thank you for your effort to make us understand the topic and not let us biased on such an important topic. Thank you, Professor. Your commitment to excellence has inspired everyone present here today. Such a tough topic made so light with your humorous illustrations. Thank you, Professor.
Thank you so much.
Thank you, sir. Thank you, sir. My gratitude to our Honorable Vice Chancellor, Professor Dr. N.S. Santosh Kumar, sir. Our dynamic Vice Chancellor has given complete academic freedom for both faculties and students in organizing webinars, workshop, training, program to benefit students and faculties across the world. Thank you, Vice Chancellor, sir, for all your support in our entire endeavor. My sincere thanks to Professor V. Balaji, sir, Registrar, the Tamil Nadu Dr. Ambedkar Law University, who has always been the forefront of every activity at the university. My sincere thanks to you, sir. I sincerely express my gratitude to Dr. R. Srinivasan, sir, Controller of Examination, Dr. R. Harita Devi, Madam, Director in Charge, Publication Academic Affairs, Dr. Kumdaratna, Madam, Director, PG Studies, Dr. Bhuvaneshwari, Madam, Director, UG Studies, for your kindness and continued support to make this event up to the mark. I would like to take this opportunity to place on record our sincere thanks to the heads of all the departments and faculty members of Tamil Nadu Dr. Ambedkar Law University. I thank the principals and faculty members of all the government colleges of Tamil Nadu, the legal luminaries from all over India for encouraging us with their humble presence and good wishes, and also providing a huge support by enabling the participation of the students in this lecture series. My heart goes on. I want to thank the wonderful participants for accepting our invitation and attending this lecture series on constitutional law. Without your kind presence, we could not have accomplished what we have dreamt for. Thank you for your participation, patience, and cooperation. Conducting this program would have been impossible without the passionate effort of our organizing team. Convener Professor Dr. Revathi Madam, Head of the Department, Constitutional Law. Co-convener Dr. Elimalai, sir, Head of the Department, Human Rights and Duties Education. Dr. Manjula Madam, Assistant Professor, Department of Constitution Law. Mr. Jay Ganesh, Assistant Professor, Department of Constitution Law. Thank you, Organizing Committee. My special appreciation to N. Harini, LLM, Constitutional Law, first year student, and S. Ashwin, BCom LLB Honors, third year, our beloved student coordinator. Thanks for being so dedicated and hardworking. Thank you, dear.
I'd like to
Let
say
us-
one word. I thank you, all of you. You spoke very well, all of you, and very good language, very good presentation, excellent. But I appreciate that Ashwin, because he kept his camera on, and I know some people are listening to, he communicated to me back feedback that somebody is listening to me. So that gave me a real classroom experience. Otherwise, we don't know to whom are we speaking, we don't know whether they are listening or not. Thank you very much for that wonderful thing, Ashwin.
Thank you, sir.
Harini also, thank you so much.
Thank you, Professor. See, this is a generosity, sir. You are so generous to thank our student coordinator Ashwin and Harin. They are really doing wonderful jobs, sir. And they are really updated. Before coming to this program, they are really updated with the topic. That is what is needed from our student, and that is what we are blessed with, having such a wonderful students in our university, sir. Thank you,
also did
Professor.
very well. You had also done a wonderful, fantastic job. Thank you.
Professor. Thank you, Professor. And let me just conclude with two more appreciation for the team members. And this lecture series like this cannot happen overnight. It requires planning and a bird's eye for details. Let us not forget the technical staff and administrative staff members who went an extra mile. Thank you so much, Dr. S.K. Ashok Kumar sir and Dr. A.J. Darwin sir, for all your support and patience. Thank you all for gracing this lecture series on constitutional law by your valuable presence. Thank you for giving me this opportunity. Thank you all. And I hand over this virtual stage to Harini and Ashwin. Thank you one and all.
Thank you so
ma'am.
much, ma'am. We need to add an extra thanks to you for delivering such a wonderful vote of thanks. And with that, we'll conclude our session. Just a small, I request the participants to please take notice of the feedback form which is being posted on the chat box. You can please fill the form in order for you to avail the certificate for having attended our lecture series. And I'll see you all tomorrow. Thank you, sir. Thank you all. Have a wonderful day.
Thank you, Ashwin.
Thank you. Thank you so much, ma'am.
Thank you, Harini.
Thank you, ma'am.
Thank you,
Kumudha,
ma'am. Thank you for acknowledging all of us, ma'am.
Thank you, thank you, thank you, dear. You're doing good job, dear. You're really updated with the session. Thank you.
Hello?
Yes, ma'am.
It's over, huh?
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Suddenly, in between me and Revati, we were not able to connect. Sir is left or sir is here?
Sir
I
has
think
left.
he has left, ma'am.
Sir is left. Oh my God. We wanted to thank him, Yeah. Say, because it was an excellent speech with so much humor. First time I'm
Yeah.
hearing. Unfortunately, we lost the connection, me and Revati. Okay, what to do? Thank you. Thank you very much.
Ma'am, I think you can talk to him privately. I suppose ma'am has his number.
Privately is different. No. Privately is different. Thanking is so much different. Thank you.
Am I audible, Ashwin?
Yes, ma'am. We
Yes,
can hear you.
ma'am.
Thank you, ma'am. Thank you, Revati, ma'am. Ma'am, you're not audible.
Ma'am, now you're not audible.
Revati ma'am, not audible.
Madam, you're not audible.
Thank you, Raji ma'am.
Thank you, Manju, ma'am. Thank you.
Thank you, ma'am.
It was really a
Thank you,
wonderful
Ashwin.
session.
Thank you, Harini. Kumudha ma'am, thank you. Revati ma'am,
The
you are not
opportunity.
audible.
Thank you, Manjula, for giving me the opportunity.
Madabushi.
Raji, we missed your vote of thanks.
Ma'am, you can see that in YouTube, I believe.
Yes, definitely. Thank you.
Thank you, ma'am.
Okay, ma'am.
Okay, ma'am, we can take a leave, I think. Thank you, ma'am. Ma'am, we can't hear you. Revati, ma'am.
Ma'am is trying to
Is
speak
it okay?
something.
It seems,
Yeah, now-
Ashwin,
Yes, ma'am.
throughout the session, you are enjoying it.
Yes, ma'am.
Okay, okay.